So welcome everybody. Happy 2022. My name is Carrie Sutner. I'm the Chief Learning Officer at the National Constitution Center, and I'm excited for our class today. We're going to talk about canonical or landmark Supreme Court cases. Really fun words that we're going to dive into, and then we're going to dive into some big cases. And lucky enough that we are here with our top scholar, Tom Donnelly. Tom, you want to say hi to everybody?
Hello and Happy New Year, everyone.
Excited to get into this, Tom, and everybody, the chat is open. So if you have questions as we go through, feel free to ask them. If you want to share thoughts you have on the cases, feel free to do that. We have some people that have actually been in a Supreme Court case in the chat, so we can share primary sources from Warren and others. But also, it's really great. Ask questions, share resources. You can do all that in the chat. So Tom, as we dive into this, and I know we have a lot of cases to get through, I wanted to just kind of lay some groundwork for all of our students. We hear these words, canonical cases or landmark Supreme Court cases, and we get the general gist of it. These are big cases that mattered a lot. But walk us through these big questions. So what technically would classify as a landmark case? So what is a landmark case? Then why do we study landmark cases? And then what have you noticed in all of your research? And I know you're doing even more research on this Founders Library project. What have you noticed are some of the big themes that come out of these court cases?
Absolutely. So, Curry, I think that landmark cases, I think actually your definition was pretty good. These are big cases. These are cases why are they big? Well, it could be because of their historical significance, sort of where the part they play in America's constitutional story. But importantly, they also have a lasting effect on the Constitution's meaning and the shape of constitutional law. And what we see is many of these cases end up either involving individual rights and liberties, or sometimes the battle between the branches of government, and sometimes the battles between the national government and the states. But again, landmark cases, easiest way, they're big cases.
And I love that. You know, I will always keep definitions simple. They're the big ones, and I like the idea, and I feel like you've said it before, and I know Akil has said it before, you know, what's that moment that, you know, tosses the stone in the water and creates a ripple? So they're big cases that make a ripple effect across our constitutional landscape. So I love that idea. And we study them for those reasons directly. So they're going to make an impact, and they're going to change the way we think and understand and use the Constitution. But what other reasons would our students, because we know so many students that go to AP classes and they have to study like a million landmark cases or canonical cases. What are some of the big reasons we study these?
Well, you can give us a sense of how the judicial branch works, how the Supreme Court works, its role in our constitutional system, how constitutional law, how the meaning of the Constitution has changed over time. And then I think a lot of these cases, what you see too, is you could really see how much the Supreme Court affects people's lives. Because so many of the cases we'll talk about today also involved as ordinary Americans.
Oh, and I love that. They really do. And there's some great images that we're going to look at in a minute. Our team member, Jenna, did a great job making sure we don't lose the people when we talk about the case, because they're the ones that are the most important. Okay, so our final kind of intro foundation setting. What are some of the themes that you notice in the cases that we picked today, but also in that big project that you're doing on the Founders Library? Have you noticed any other themes that have come up?
Well, no, I think these themes, so let's tick through the ones we have. I think these really do capture most of the landmark cases. So there are just some cases that are Supreme Court foundations. So these are early cases in the Supreme Court's history that really establish important baselines for what the Supreme Court's going to do and what the Constitution's going to mean, and frankly, what the Constitution's going to do. But then over time, we also see some other themes picked up. So one, we see battles over the Constitution's promise of equality. And so this goes everything from the battles over slavery in the early parts of America, all the way up to the meaning of the 14th Amendment's promise of equality into the 20th century and beyond. We also see another key theme being the Bill of Rights. And so the battle over those cherished liberties we enshrined in the Constitution in Amendments 1 through 10, we see these battles especially pick up in the 20th century and beyond. And then finally, Curry, I would say the other big one that we have here, we have battles over presidential power, but I think even more broadly, it's the battles between the branches. These battles over the separation of powers, often pitting the presidency against Congress, or sometimes they're battles over federalism. So battles between the national government and the states, and over how much power goes to the national government versus how many go to the states. And then in our classes, we often focus also on the role of the Constitution in the schools, because the Constitution often has different rules that apply in the schools versus what happens outside of the schools.
Oh, and I think that's really important too, because if you learn the First Amendment just the way it works in schools, you don't see how it works in everyday life, or vice versa. So you almost have to look at it in two separate groupings. Now, what I wanted to do to make sure that everybody could see this, this is our agenda. We probably won't get to it all. I always say those things out loud, but I wanted to make sure this PowerPoint's on our website, and all the teachers, all the adults, all the students can download it all they want, but they can see the list of cases that we're going to go through today in looking at those themes that Tom just walked through, but also the years of these cases, because I know a lot of our students want to know what's the exact name of the case and what's the year, and that's really good to kind of anchors in the sand to put things around. So our first thematic grouping is going to look at these first two landmark cases right here, and we're going to dive into the foundations of the Supreme Court and how the Supreme Court works. So these are two big ones, Tom, but dive into it. Tell us the stories, tell us the people, and what precedent did they set?
Absolutely. So, I mean, the thing to note here is that the Supreme Court foundations, these cases are happening in the early part of American history. So it's the early 1800s. What we know is that at the beginning of the American Republic, the Supreme Court actually wasn't that important. It wasn't that powerful. The other thing to note is that the early Americans really had to figure out, how is their new government going to work? How is their constitution going to work? And so there's a lot that's going on in these early years to establish baselines for everything we build on after that. And so these cases really go to, one, the role of the Supreme Court in our constitutional system, and two, a bit about how we're going to go about, one, reading the Constitution, and two, how we're going to battle over the Constitution's meaning over time. The last thing I'll say is that both of these cases involve one of probably the most famous Chief Justice in all of American history. This is John Marshall. So these are the years of the Marshall Court. They run from 1801 to 1835. But a key theme of this period is that John Marshall and his colleagues on the Supreme Court are going to build up the Supreme Court's power and legitimacy, and also read the Constitution in a way that gives it a fairly broad reading of Congress's powers to regulate the economy. So that's a bit about the foundations more broadly, but let's dig into that first case, Curry. Marbury versus Madison. It's again such a canonical, such an important case. It was decided in 1803, and so the case itself involves two of the great frenemies in American history, and so this grows out of the election of 1800 between John Adams and Thomas Jefferson. Jefferson wins. He's exuberant. He proclaims the Revolution of 1800. John Adams loses. And he's angry and he's sad. And John Adams, frankly, often is angry and sad. But so this case arises out of sort of the closing days of the Adams administration and what we know of today as the so-called midnight appointments. And so as the Adams and his Federalist Congress are leaving office, they create a bunch of new positions for John Adams to fill before Thomas Jefferson becomes president. The idea being they want as many Federalists in office, these would be political opponents of Thomas Jefferson, to try to lock in place a lot of what the Federalists thought they gained under George Washington and John Adams. And so we see here the case is Marbury versus Madison. Who are those two people? Well, first, William Marbury. You can see him right there. William Marbury, who is he? Well, he's a well-connected Federalist. He's from Maryland. He grew up on a tobacco plantation. He's the equivalent of what we would think today kind of as a big political donor or a political insider. And so what happens is in the closing days of the Adams administration, he gets the position of Justice of the Peace in Washington, D.C. Congress passed a new law that allowed John Adams to fill these vacancies. And so John Adams wants to place William Marbury in this position of Justice of the Peace. And this case is all about William Marbury really, 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 really wanting that job. Who's Madison? Yeah, he's that Madison, James Madison. He's the father of the Constitution. And so this is just a really, in many ways, the facts behind this case are really weird. So what happens? John Adams, he writes it. So what's a commission? A commission is just a piece of paper. And John Adams writes out a piece of paper saying, William Marbury, you can be a Justice of the Peace in Washington, D.C. He puts it in an envelope. He seals the envelope with the seal of the United States. So the commission is signed, sealed, but William Marbury's commission is never delivered. It is not delivered to William Marbury before Adams leaves office. So there's this commission, this piece of paper in an envelope sitting on James Madison's desk that says, William Marbury, you can be a Justice of the Peace. What does Thomas Jefferson do when he comes into office? He says, hey, Mr. Madison, you know that piece of paper on your desk? Stick it in the drawer. We're not going to deliver these commissions to these different Federalist officers. It was illegitimate for Adams and the Congress to create these positions to begin with. We are not going to let them take office. And so Marbury comes to court and he asks the Supreme Court to issue what's called, the fancy word is a writ of mandamus. And so all that this means is it's an order that would say, James Madison delivered the commission to Marbury. And so the Supreme Court gets this power under the Federal Judiciary Act. And so Marbury comes to court and he says, Marshall Court, Supreme Court, give me my job. I'm given this job. And so what does John Marshall and the Marshall Court say? They say no. They say, no, Mr. Marbury, we cannot deliver you this job. Now, why do we study this weird case? Well, part of the reason, there's the drama, so there's the good story. But really what we take Marbury versus Madison to be is it's an important precedent for the Supreme Court to have the power of judicial review. And so this is that supreme power, this really important power to review acts of the national and state governments and say whether they're constitutional or unconstitutional. It's what we really think of the Supreme Court doing in, a lot of their constitutional cases. And so what Marshall says here is he says, one, you know what, Mr. Marbury, you have a point. You really do have a right to this job. Two, Congress really did give us this power to issue a writ of mandamus. But three, that law passed by Congress was unconstitutional. It was unconstitutional for Congress to give us that power. As a result, you may have a right to this job, but we have no power to give it to you. And so that's the baseline there, Curry.
Awesome. And it is, sometimes people get confused with this case because it is a little bit of a shell game that he plays in his opinion, but it's really interesting to kind of lay out within that shell game. I'm gonna do nothing, but at the same time, tell you how much power we do have. I think it's a fascinating case. Side question, what does mandamus mean? Like, is it a Latin term meaning to power to take or something?
It must be a Latin term of some sort. I can't say, Kurt. All I know is that it's literally, the writ of mandamus is the court telling a government official to do something. So it's not just deliver a job, it could be anything, but it's just like, it's a court telling them to do something.
Okay, so everybody, we have now Latin homework, just if we're clear. Awesome storytelling. I really like it. This one makes me laugh as you tell the story every single time. But it's an important case, and it talks about that big idea of judicial review. Again, why do we study landmark cases? Because they define things and how our system works, and we can understand the basis around it and then the outcomes of it and how they affect you today. So awesome story, kind of walking through our next. You want to jump to our next big one? We'll jump to McCulloch versus Maryland.
Absolutely.
Okay, dive us into this one.
Okay, so McCulloch v. Maryland, the decision was issued in 1819. It's another Marshall Court decision written by Chief Justice John Marshall, and it tackles one of the big constitutional questions in early America. And that's, does Congress have the power to establish a national bank? And so this may seem a bit obscure to us today, like why would that matter? The way to think about it is the battle over the Bank of the United States in early America was about how much power Congress and the national government was going to have over the economy more broadly. How much power would it have to really shape big national economic policy? And so this battle over the constitutionality of the national bank, it goes all the way back to the Washington administration. And so the first national bank was created by the first Congress and signed by George Washington. But there's a huge battle in Washington's cabinet over whether this new law is constitutional, whether it's constitutional for Congress to establish a national bank. It's the centerpiece of Alexander Hamilton's economic program. So he says, yes, the national government has this power. You know what? If we want to become a big and powerful country, it's important for the national government to be able to do big things and to be able to shape economic policy in important ways. What Hamilton said is a national bank's really important for our ability to do that. It's something that as a result of that, the Constitution itself is broad enough to encompass the power to establish a national bank. But on the other side are really important, powerful constitutional voices. We have Thomas Jefferson, the Secretary of State, James Madison, who's sitting in the House of Representatives, who say, Alexander Hamilton, what are you talking about? We created a national government of limited powers. You think Congress has the power to establish a national bank? Where does it say that in the Constitution? There's no charter bank clause of the Constitution. So what you're asking us to do here in the first Congress and in the first administration is unconstitutional. It exceeds Congress's powers. Congress doesn't have the power to establish a national bank. But the battle over the bank and the powers of the national government continue. And eventually we establish a second Bank of the United States. And then the constitutionality of that bank comes before the court in McCulloch v. Maryland in 1819. And so one thing to note that's kind of interesting, Curry, is this reminds us that in early America, some of the biggest constitutional questions are first decided outside of the Supreme Court. So who's deciding on the constitutionality of a national bank in the first place? It's the first Congress, and it's the Washington administration. The Supreme Court didn't step in and say anything about the constitutionality of a bank. It's only decades later in McCulloch in which they're doing that. And so we even see here an expansion of the court's role in constitutional questions in the United States. But McCulloch v. Maryland involves a battle between the state of Maryland, as you can say, and James McCulloch. So who's James McCulloch? He's a bank official of the Bank of the United States. What Maryland has done here is they have said, we do not like the Bank of the United States. We believe it's unconstitutional. We don't want the bank in the state of Maryland. So what are we going to do? We're going to use Maryland's sovereign taxing power to tax the bank out of existence. We're going to tax the bank out of existence in Maryland. We don't want it here. And we're using our state power to do that. And McCulloch says, I'm part of the national government. I'm not paying your state taxes. And so there's this battle here between Maryland and the national government. And frankly, Maryland makes the same arguments that Jefferson and Madison made, saying that the Bank of the United States, anyway, it's unconstitutional. Congress shouldn't have been able to do it in the first place. There's no charter bank clause of the Constitution. What's so significant about this case in many ways is what Marshall says in reply. And what he says is, guys, what you're doing constitutional law wrong. You're reading the Constitution the wrong way. What is the Constitution? It's a small document that every American has to be able to read. We had to be able to give our assent and say yes to it to begin with. If you're going to write down literally every little thing Congress has to do in every detail, the Constitution is going to be the size of Princeton, New Jersey, where I live. It's going to be humongous, and no one could read it and see what's going on. And so in the end, we need to read the Constitution differently. And so what Marshall does is he puts two clauses of the Constitution together and says the Congress has the power to establish a national bank. How does he know this? He says, one, Article 1, Section 8 of the Constitution grants Congress a wide range of powers, including the power to regulate interstate commerce, borrow money, to tax, a bunch of things that have to do with the economy. Raise an army, it's useful, you need money to raise an army, all of these different things. The Constitution specifically says Congress has those powers. Plus, there's also a clause in there known as the Necessary and Proper Clause, which gives Congress also additional powers to do things that are necessary and proper for carrying out the powers that are listed in the Constitution. And so what Marshall says in McCulloch effectively is, if you read together the powers Congress has and the flexibility provided by the Necessary and Proper Clause, of course, establishing a national bank is related pretty closely to a lot of the powers that Congress has under the Constitution. And so what the famous line here, Curry, is from Marshall, let the end be legitimate, let it be within the scope of the Constitution and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consistent with the letter and spirit of the Constitution are constitutional. What Marshall's effectively saying is Congress is going to be able to do some specific things that aren't written clearly in the Constitution. The last coda here, Curry, is that people have battled over what Marshall meant by that for all of American history. And these battles between Hamiltonians saying the Constitution grants the government a lot of power and Jefferson and Madison saying, no, it's a government of limited powers, battles over the powers of the national government, needless to say, they never go away.
And it's amazing. And I always think to myself, is the question is because this is like the first court that's really, moving, looking at cases and doing this, or is it because of John Marshall? And I'm pretty sure the answer is both. But like this groundbreaking work that's laid out in these two cases that really kind of sets the precedent, and not only what we should do, but what does he actually mean by that as we go through. So we talk about judicial review. We talk about, and Uriel pointed this out in the chat, we get the powers of Congress are so defined in these two cases as well, what they can and they can't do. So it's not just saying what the court's job is, it's also saying what Congress can and can't do, and it's not going to be down to the word for word letter. There's these big ideas in there too. Do you want to talk a little bit real quick before we jump to the next group of casing about the supremacy clause as well? Because this comes out in this case as well.
Yeah, so part of this too, the last part of the case is, what Maryland's trying to do is it's using power it has to try to tax the national bank out of existence. What Marshall says, he says two things. He said, one, Article 6 of the Constitution makes the Constitution and national law supreme over state law. And as a result of that, Maryland can't use your state power to defeat something the national government has done. And so what he says in this, the famous line is, the power to tax is the power to destroy. And so in part, what Marshall's saying here is that, when something the national government's doing conflicts with something the state government's doing, and they're both within their powers, the national government wins.
Cool. So great. Judicial review, supremacy, powers of Congress, power of the courts, all these big ideas come out of this. Now, looking at the topic that we talk so much about when we talk about the Constitution is it really, is sparked in the Declaration of Independence, this idea of the promise of equality in the Constitution and how it finally gets into the Constitution with the 14th Amendment and these three cases bundled together. So walk us through the big idea of these cases, and then we'll go through each one of them so our students know what happened and their huge significance.
Yeah, absolutely. So these three cases are really about battling over, we can in many ways say, the Declaration of Independence's promise of equality, going from Dred Scott v. Sanford, an important case about slavery, to Plessy v. Ferguson, an important case about Jim Crow segregation, and then Brown versus Board of Education, the case that really breathes life into the 14th Amendment's promise of equality once again.
So let's begin with Dred Scott case, so Scott v. Sanford, but let's begin with Harriet. And what did Harriet want to do, and how did this case change the country?
Yeah, so Dred and Harriet Scott, they're an enslaved couple. And so Harriet Scott, she's a mother. She has two young daughters. And what this case is about in many ways is not wanting those daughters to end up within the institution of slavery and the brutality of that institution. And so she convinces her family to bring this case in court. It's what's known as a freedom suit. And so it's enslaved people arguing in court that they should be free. The argument of the Scott family is that the slave owner in this case took them into an area where slavery was banned and then brought them back into an area where slavery was legal. And what they argue is that by being placed on free soil, we ourselves are free. And so it takes 11 years for this case to weave its way to the Supreme Court. And the Supreme Court in the end says, no, Scott family, no, Dred and Harriet Scott, you lose. And so this is an opinion by Chief Justice Roger Brooke Taney. And what Roger Brooke Taney effectively does is he looks at American history. He looks at sort of how African Americans have lived in America over time. He looks back, especially at the framing and ratification of the original Constitution. And what he says two big things. He says, really three. He says, at the ratification of the Constitution, African Americans could not be citizens. And so as a result of that, what the two big things that Taney says here in Dred Scott are: one, African Americans cannot be United States citizens, and two, that they, quote, had no rights which the white man was bound to respect, and that in the end, because of this, you, Scott family, have no right to be in court, you have no power to be here, so you have to go away. And so this is a really deeply hurtful opinion to read today. It's one of the most infamous opinions in Supreme Court history. It's in many ways the most important decision about slavery prior to the Civil War. But the coda here, Curry, is that Taney's arguments don't go unanswered in his own time. And so there are two powerful dissents in this case, one by Justice Benjamin Curtis, one by Justice John McClain. Benjamin Curtis actually resigns from the Supreme Court in protest after Dred Scott because he was so outraged by the decision. But effectively what these dissents say is, Justice Taney, you got your history wrong. Look back at history, look back at the founding. African Americans could be United States citizens. They could vote. That's always been a part of American history. It's not as though African Americans have been treated well throughout this period, but the idea that they can't be United States citizens is ridiculous. And then finally, Curry, it's out of Dred Scott where we see Abraham Lincoln and the Republican Party speaking back to the Supreme Court saying, Supreme Court, you are not right about everything. In fact, you're really, really wrong about this. And it's our role as citizens, as political leaders, to speak out when the Supreme Court is wrong.
And it's unbelievable because in this case, you see kind of the greatest part of America with Harriet Scott fighting for freedom and calling to the Declaration to protect her children. And at the same time, the horrible outcome of Justice Taney. And then the dissent that happens right away, but then again, by all the people that push back and say, no, this is not right. This is not who we are. And this is not our Constitution. that moves us forward to the 13th, 14th, and 15th Amendment. And I feel like you have to nod to those, Tom, and I know you want to, real quickly before we get to Plessy.
Yeah, we have obviously we fight a civil war. After the Civil War, we ratify a series of 3 transformational amendments. The 13th abolishes slavery. The 14th writes the Declaration of Independence as promise of freedom and equality into the Constitution. And the 15th Amendment bans racial discrimination in voting. But as we flash forward roughly 40 years from Dred Scott to Plessy v. Ferguson, we see here a battle over what is the meaning of the 14th Amendment's commitment to equality. And so what happens here is that Louisiana passes a law, an early Jim Crow law, that says, that passengers on rail cars have to be, African Americans and white passengers have to be in separate cars. And so this is just classic racial discrimination, racial segregation. And so the question is this constitutional? Is this consistent with the Reconstruction Amendments, the 14th Amendment's promise of equality? And the Supreme Court, in a 7-1 decision, says yes, this Louisiana law segregating African Americans and white passengers, it's constitutional. It's consistent with the Constitution, doesn't violate the 14th Amendment, doesn't violate the 13th Amendment, which abolished slavery. The justice who wrote the opinion here is Justice Henry Billings Brown. And what he effectively says is a law like this it's right within a state's power to regulate the health, safety, welfare, and morality of their citizens. And then he has the audacity to say, and by the way, African Americans, if you think that this law is somehow speaking ill of you or making you second-class citizens, that's on you. The law doesn't say anything like that. All it says is that we have to separate African American from white passengers. This is where we get the idea that separate but equal laws are constitutional, that if you provide separate facilities that are equal for African Americans and white Americans, that is constitutional. But again, Curry, in many ways, the most powerful part of this case is the dissent by Justice John Marshall Harlan. He's the one. And in many ways, he writes one of the most famous opinions in Supreme Court history. And he says what we're all thinking, which is, Justice Brown, are you crazy? Are you crazy? In what way is this law equal? How is this equal protection of the laws? And Harlan would famously say, the Constitution is colorblind. And he would predict that Plessy v. Ferguson would one day become just as infamous as the Dred Scott decision. And so it has.
And I think, again, this story in this case, and it leads to Brown next, really lay out the fight and the battle. I love talking about Homer Plessy and how he was a test case and he was going to fight this battle. And part of it was, what is the idea and meaning behind separating the races? How can you tell? He was a very light-skinned African-American, and it was saying, you can't tell. This is just a judgment. You're trying to make a judgment on who I am based on the color of my skin. That's not right. And that's what Harlan says in his dissent. One of my other favorite stories that's all this is connected is Harlan in these cases, in the civil rights cases, has a bit of a writer's block. And his wife borrows from the court Taney's inkwell that he used to write the Dred Scott decision, and basically hands it to him and says, like, get over your writer's block and do something about this. You need to break through. He uses that to write the dissent. But what I love about the story, and I just found out from reading another book, is that the Taney family wanted that ink block back years later, and his wife hid it and gave it to a museum so it would stay in the public square, which made me laugh really hard. I know, I really, really like his wife. Now, moving forward to another strong freedom fighter that kind of kept pushing, even though the odds were against them, almost 100 years later, we get to Linda Brown. So tell us about Linda Brown, how it's connected to the Plessy case and the separate but equal standing that she's living under.
Yeah, so this is Brown versus Board of Education. It's 1954. The Brown is Linda Brown. Great picture. She's a third grader. And what's going on in this case? Her parents just want her to go to the school that's near their house, the Sumner School in Topeka, Kansas. And the school district says no. Why do they say no? Because of her race. It's an all-white school. She can't go. So this is much like Plessy v. Ferguson. It's Jim Crow segregation, saying that African-American students and white students have to go to separate schools. Linda Brown and her family argued, no, this violates the 14th Amendment's Equal Protection Clause. Brown itself brings together a bunch of other cases like this one from throughout the country, and they all issue the same argument. And they say, court, now is the time to overturn Plessy v. Ferguson, to say separate but equal is unconstitutional, and that segregation, Jim Crow segregation, violates the Constitution. And the Supreme Court says yes. Finally, we have a Supreme Court battling for equality and the promise of the 14th Amendment. And it's an opinion by Chief Justice Earl Warren. And what he says famously is, we conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. So the court says, we got it wrong in Plessy. The 14th Amendment promises equality. We are going to provide full equal citizenship for African Americans. Schools that separate white Americans from African Americans, they're unconstitutional. You can't do it. Even if the facilities were equal, which they never were, even if they were equal, they're unconstitutional because they brand African American children with a feeling of inferiority, of second-class citizenship, and we can't do that in America. The last piece here, Curry, is that this decision didn't come out of nowhere. It grew out of years and years of work by the civil rights movement, and also inside the courts by the NAACP and the famous lawyer Thurgood Marshall, who brought case upon case that chipped away at Jim Crow segregation until finally we get the unanimous decision by the Supreme Court in Brown versus Board of Education saying Jim Crow has to go.
Awesome, great. And we're a little bit out of time, but I'm gonna have one more case. I knew we wouldn't get through the whole list. Korematsu, and I know a lot of our students need to study Korematsu, and thinking about this idea and theme of equality and fairness. I think ending with Korematsu would be a great way to end.
Absolutely. So Korematsu, it's Korematsu versus United States, 1944. It involves FDR's order to place Japanese Americans into internment camps during World War II. And so, it's a decision. So it's one, that executive order, but the Supreme Court decision itself, in many ways, it takes place in the fog of war, where people are concerned about national security. And it's a reminder that a lot of landmark Supreme Court cases are about how do you maintain faith in the Constitution and the Constitution's power in the face of fear of national security, especially in times of war. So it's a recurring theme. Who's Korematsu? He's Fred Korematsu. He's a 23-year-old Japanese American, and he refused to go to the internment camps. And so, he was born in California to Japanese immigrant parents. So Korematsu is a Californian. He's an American citizen, and he's saying, how in the world can you take an American citizen and say, I have to leave my home and live in a terrible, terrible place? And he says, no, I'm not going to do that. And so this case ends up working its way up to the Supreme Court. And today we may look at this and say, what more clearly violates the Constitution than this? You're treating an American citizen differently just because of his race. What else do we need to know about this case? But the Supreme Court, in a 6-3 decision, upheld FDR's order. They said what FDR did here was constitutional. And so in part what the Supreme Court says is, it's wartime. The national government has broad power to carry out a war. Congress has established sort of broad authority for the president to do what's necessary to win this war. We're not putting Korematsu and his family and his fellow Japanese Americans in internment camps because of racial animus. We're doing it because we're genuinely fearful for national security. So the Supreme Court ends up deferring to the national government, and FDR wins the case. But as you can see, a recurring theme today, there are powerful dissents in this case. And so there are three of them, one of them by Justice Frank Murphy, who describes the court's decision as going into the, quote, ugly abyss of racism. We see Justin Owen Roberts likening the decisions made here to the sorts of things that authoritarian regimes, the ones that were fighting in World War II, would make. And then finally, we see Justice Robert Jackson in a powerful dissent saying, look, I used to be the Attorney General of the United States for FDR. I understand the importance of national security. And I think usually we have to defer to the national government when they're carrying on fighting a war. But this establishes a terrible precedent. It says that racial discrimination in the service of national security is okay, and that this precedent is going to hang around like a, quote, loaded weapon for future presidents to take on and really exercise almost unbounded power in wartime. And so that's the case itself, but the case has an amazing ending as well, because decades upon decades later, after many, many years of advocacy by Fred Korematsu, by other Japanese Americans, the national government finally acknowledged that they got it wrong. And so Congress studies the internment, issues a big report, and even issues reparations to Japanese Americans for the internment policy. And finally, Fred Korematsu himself battles on and says, I want my conviction overturned. And finally, his conviction is overturned. He gets the Presidential Medal of Freedom. And finally, the Supreme Court just recently in Trump v. Hawaii has said what we have always known, and that's that Korematsu was gravely wrong the day it was decided, has been overruled in the court of history, and to be clear, has no place in law under the Constitution.
Awesome, Tom. Thank you for ending on Korematsu. And when we talk about landmark and canonical cases, we really always want to make sure we tell you about all these amazing people who did amazing things to fight for freedoms for everybody. And I love these cases. It's just like Korematsu, like Linda Brown, like Harriet. You have so many powerful people that even though it didn't always side on their way, that they fought to make it a better United States and a better court. So thank you so much. That was great storytelling. And if you want to dive in deep, the Korematsu story is one of the most powerful stories I've ever read. So check it out. We can send you some books in the Friday roundup as well. Thank you, Tom. Sorry we didn't get to every story, but they were really good ones. So I appreciate it, everybody, and have a great day, everyone.
Thanks, everyone. Thanks, Curry.
Thank you, Tom.
No problem, Curry. I think last year we gave ourselves 38 minutes, so I could have gotten Barnett in.
Well, we also had Tinker, so I knew we weren't going to get.
We didn't get to Tinker last year.
But it was like, I would end on Korematsu because I really like that story, and you tell it so well.
Yeah, no, it was a good way to end.